This is the response from my lawyer, Ron Coleman, and we are going to just go through what he had to say. Last we left off was the, I believe, 89-page. It was called the Second Amendment Complaint. So they had the lawsuit initially, they had an amended complaint, and then they had a second amended complaint. Because these lawyers really have their shit together where they keep needing to amend things instead of knowing what they're actually suing someone for. They just keep going back to the drawing board. In my humble opinion, it is a complete IT show behind the scenes, but who knows what the judge will say about any of this. But here we have a letter from Ron Coleman to the judge, Honorable Margot K. Brody. And he said, "Dear Judge Brody, we represent defendant Jeff Tarzia in the reference matter and submit this correspondence pursuant to your Honor's pre-motion letter requirement. Defendant wishes to file a motion to dismiss the Second Amended Complaint, SAC, pursuant Federal Civil P12B2, based on the lack of personal jurisdiction, and Fed R Civ P12B6 for failure to state a claim, as well as appropriate relief under New York's anti-SLAPP statute." So in this first paragraph, this is a summary of what this is all going to be talking about right here. He's saying multiple reasons why this should be dismissed. The first one being that they can't legally sue because I'm in California and she's in New York. There is no jurisdiction, and you cannot use the internet as jurisdiction. That has been established as a based fact in the court of law. So that is one of the biggest hurdles they have to overcome to even get this heard. And Ron's like, yeah, put it on the tee. I'll knock that one out because that's pretty obvious. Secondly, and this is what I was saying earlier, they don't state a claim. Like, I don't know what they're even suing for. It's just a bunch of words and 89 pages of accusations. And I guess you could say it culminates into, because of all these words, it's harassment. But it's like, no. First off, you're a public figure and you're writing some pretty lambasting words out there. Of course, you're going to get criticism back from people. You need to expect that, especially if you're going to be inflammatory with the words you write on social media. So I don't really understand what the case is here. And then the third thing he says is also, as well as appropriate relief for anti-SLAPP statute. So he is going to talk about at the end of this how, in addition to Alyssa having this get thrown out, Alyssa will need to also pay everything that I've been paying to Ron. So he wants the judge to acknowledge the New York anti-SLAPP statute, which is a powerful statement. And one could argue the reason why anti-SLAPP was created in the first place, which is what we were saying from day one with all of this. The SAC has been tailored in an attempt to address the deficiencies identified by the defendant in the original complaint, particularly in terms of specificity, legal sufficiency, and alternative claims. That attempt, however, falls short and in some respects has resulted in a pleading that is actually legally weaker than the original. I'm laughing because, like, I'm not a lawyer, and this is what I took out of reading it. I'm like, this feels like it's less of a case now. So I find it pretty funny that my lawyer is reflecting exactly what I felt after reading it. I'm like, yeah, this is, what are they? And he says, we briefly addressed the issues below. First, personal jurisdiction. Like the original, the SAC acknowledges Mr. Tarzia is resident of California. Plaintiff added allegations to the original allegations that Mr. Tarzia directed his conduct toward plaintiff in New York, resident, and that his website can be used in New York. A series of novel allegations. And for those that don't know novel, I believe this is legal terminology Again, not a lawyer, so take this with a grain of salt. I believe novel means like not typically something that courts will hear because it's not like approved or something that's been accepted in the past. So novel means like new to the court. So it's a series of novel allegations that that I have friends in New York, none of whom are defendants, but who also allegedly harassed the plaintiff. The SAC also alleges that because Mr. Tazier publishes his website using a service in New York called Wix, which in turn has a forum selection clause designating New York, none of these allegations prove valid grounds for asserting personal jurisdiction under CPLR 302A2, which, again, this is from day one. This was always going to be the biggest hurdle that she had to get over, and it still remains to be. Like, you don't have jurisdiction. It's almost like a police officer going into another state trying to pull someone over. It's like you can't do that. You work for the other state. You don't work in this state. You can't pull someone over for speeding over here. You can only do that in your state. Or 3, whereas here, the only tort alleged to have committed is defamation of character. Anyway, so he's putting this all together as personal jurisdiction and saying, yeah, whatever they're saying, none of it matters because I'm in a different state and it doesn't qualify. Which, again, I'm no lawyer, but if this does get approved, this would be the biggest point of contention that I'd have with the whole thing. I'd be blown away. I'd be like, whoa, they don't do this kind of thing. Why are they even hearing this? This is wild to me. Which I go back to, why did her lawyers even hear this case in the first place, knowing that going into it? At least I'd like to think they know that going into it. Failure to state a claim, number 2. The SAC expands its raft of allegations concerning political, social, culture war topics and, like its predecessor, is jammed with political rhetoric and polemic. But these add nothing to remedy the pleading deficiencies of the first complaint, which I would agree. The complaint wasn't about a culture war or social political topics. This new amendment that they threw in there has a bunch of culture war Gamergate stuff. It's like, what does this have to do with what you're suing me for? As a threshold matter, defendant respectfully submits again that the SAC epitomizes the kind of pleading referred to by this court in Reach versus Lopez when it wrote, so it's this court that he's referencing a previous case. Although plaintiff's claims include, in addition to defamation, tortious interference, and prospective economic advantage, trade libel, and injurious falsehood, all of these causes of action sound in defamation. New York courts treat harm stemming from injury to reputation as sounding in defamation and do not recognize separate torts as additional causes of action. Damn. This is why you pay for a lawyer. I'd be like, oh, cool. I didn't even know that existed. Plaintiff has shifted her emphasis away from that found in the original complaint, the operative allegations of which were the defendant referred to the plaintiff as a whore and sex worker, constituting an actionable offense to the plaintiff's reputation for chastity, which, by the way, that was one of the main points in the original one, and they kind of backed off that one in the update. And it's like, okay, so now what are you suing for? I thought this whole thing was because she was mad she was called a whore, and now she's saying, no, that's not really it. This is really what I'm mad about. The SAC is, in contrast, acknowledges, as it must in response to the proof laid out in defendant's motion to dismiss, that plaintiff has admitted saying both of these things about herself. Now, however, the gravamen of plaintiff's per se claim is that the defendant falsely accused her of committing the crime of prostitution. Again, plaintiff admits that she has been a sex worker, which is defined as, I love this, he's reiterating what he said the first time. He's like, in case you missed it, Your Honor, this is the same thing I told you before that they're pushing forward. which is defined as a person whose work involves sex acts, especially a person who engages in sexual intercourse in exchange for pay. She also acknowledges that she has frequently spoken on the topic of sex work and does not consider sex work to be improper. Again, if she really did consider it to be improper, then why didn't she have an issue when Jaffe said this?
If it was consensual and you didn't hate the Jews, I'd fuck the shit out of you. I would.
Oh man, sure. The stop didn't sound like she hated it. That almost sounded like a flirting stop. If I were a lawyer, I would be like, doesn't sound like she's taking much of an issue with that one. And oh, by the way, you're currently suing someone saying that you take such offense to this that you want to ruin their life. You seem fine with it when Jaffe says it to you. That's weird. Yet her defamation case rests on the premise that when she posted the tweet above, defendant not only could not have reasonably interpreted it to mean the plaintiff exchanged in sex for money, but that Mr. Tarzier must have known that she had never done so and was intentionally lying when he said she had, which, to be honest, I fully assume that she was this in the past based off of the many tweets that she has said. This still holds true today. Many of those tweets that she tried to delete that we have backed up on a video, and plenty of other places and files as well that will come out in court if it gets that far. This argument is not sustainable as a matter of law. The SAC also includes an unusual argument, in quotes, at 362 to 363, in anticipation of an obvious problem raised by another plaintiff's tweets shown below. So 362 to 363, let's go to that real quick. Tarzier will likely argue that so they're already assuming what I'm going to do, will also likely argue that a December 21st, 23 tweet from Mercante that she should go back to sex work because at least then when I get effed a lot, I'll get paid well for it. This statement is followed by a laughing emoji with its tongue hanging out. This statement is obviously a joke. No, it's not. To me, a sex worker saying go back to sex work because you get effed a lot with emoji with a tongue hanging out would be interpreted as, that's a crazy bitch. Like what? That's how I interpret it. What the hell? I mean, how are they telling me how I interpret something? That's crazy. So he's saying here, the unusual argument in anticipation of an obvious problem raised by another plaintiff's tweet, and this is the tweet that they don't show, by the way. So here it is being shown, responding to the intuitive interference from the above post that, in fact, plaintiff has engaged in sex work, and that term is universally understood. The SAC posits the following. The argument that a laughing emoji makes it obvious that what preceded was just a joke is a dubious one that has been found wanting in innumerable contexts. In fact, the obvious interpretation of this emoji is that the plaintiff was making fun of her own double entendre, a double meaning that, again, relies entirely on the reader understanding sex work, not to mean, as the SAC claims, selling erotic pictures. The SAC should be dismissed with prejudice. This is a banger. Have not seen says this is the easiest $25,000 Ron has ever made. I mean, to be fair, you never know. You never know. Again, I'm not assuming a victory until there's a victory. But damn. Now here we get to the good stuff here. Anti-SLAPP sanctions. Unfortunately, it is evidently not obvious to plaintiff that pursuing this flimsy claim is no joke. That is why, in addition to seeking dismissal of the SAC, Defendant will also ask the court for sanctions because this meritless lawsuit is an action involving public petition and participation, prohibited by the NYCRL. Attorney's fees shall be recovered upon demonstration that an action involving public petition and participation was commenced or continued without a substantial basis in fact and law. This is such an action, and its lack of substance will be readily demonstrated by the defendant's proposed motion. Anti-SLAPP sanctions will vindicate the entire policy and purpose behind New York's law and send an important message to litigants seeking to chill speech and score political points by prosecuting meritless lawsuits such as this one. Respectfully submitted, Ron Coleman. I mean, damn. I don't even know what to say, except I couldn't have said it better myself. And I would like to think, if there is justice in this world, looking at the allegations that are, what did I say, 79 pages? Is it 79 or 89? 89, I had to double check. 89 pages. And then Ron's just like, here's 3 pages of, this is a complete joke, and here's why. So stop wasting your time with this. I'd like to think justice will prevail. The Honorable Margot K. Brody will look at the situation for what it is and be like, yeah, this is ridiculous, and the defendant should get all attorney's fees paid back to him. So we'll see. We'll see where this goes. But that's where we're at right now. Alyssa has her team. It's a team of 3 lawyers, as far as I understand, submitting an 89-page Second Amended Complaint. And now Ron Coleman has responded, defending me, with a 3-page rebuttal and request for, you call this a request for dismissal? I think that's what it's called. Yeah, motion to dismiss. Filed a motion to dismiss. Again. So this is now the second motion to dismiss. So now both parties have responded. And as far as I understand, it is now up to the judge to review the information and now make a decision on, like, shit or get off the pot. Are we going to hear this case, or are we going to throw it out, or are we going to have some sort of other option between those things? So I'm curious to see what happens next. But one thing's for sure, my promise to you guys is I will be as transparent as possible with everything that comes through, and I will be hiding absolutely nothing from anything here. So that's all I can do. Shout out to all you guys, and thank you again for all your support on all of this. Oop Omo Poo says, so no more redrafts from Mercante? I mean, at this point, no, but you never know. Like, the judge could theoretically, like right now, it's up to the judge. Judge can basically determine anything. I think the judge could say, hey, I need more clarification. Could you please rewrite a 3rd time? Like, that could, I don't see why. I'm not a lawyer, but I could see that being an option. I think, like, judges have ultimate reign and power of whatever they want to do next. So we'll see. We've done everything we could. And to me, we've done everything perfectly. Like, I couldn't have asked for better representation. And this would be a honest 5-star review, regardless of what happens from this, because Ron Coleman has been absolutely incredible. But yeah, I'll leave that one there. And does she get a certain number of do-overs, says Sergeant Sapient? Again, it's up to the judge. All this is up to the judge now. We have gotten to the point where we're finally, like, submitted everything. And until I hear more, this is now up to the judge at this point. Hath Not Seen says, I highly doubt a judge is going to want to sit around and listen to this nonsense. I could only imagine. Like, I try to take my bias out. I know it's impossible to do, but I try my best to read it, their original complaint, and then their redraw, and then their redraw. And I have a really hard time reading it and really finding any actionable offenses. It's just a lot of words like, "Oh, I'm mad that he said this about me." That's not defamation, that as far as I understand. Because holy crap, could you imagine? "I'm mad you said this about me" is defamation. Could you imagine how many lawsuits would just work? Like, yikes. And if that's the case, I'm going to go right ahead and sue back. She said a lot of things that I felt were very rude and I did not like. So like, what the hell? Easy Big Oven says no sensible judge would take them seriously. Then again, it is New York. ... Yeah, you never know. If you lose, what is the appeals process? I have no idea, JJJ. I have no idea. Like, genuinely no idea. I haven't even gotten that far because I'm like, I would like to think it doesn't get there. You know what I mean? Old Man Grimm for the 5 says, did you Google the judge? I worry that's why they included the stuff labeling you as a racist in their filings to play on any sympathies. That is a concern. That is a concern. That's a legitimate concern. At this point, it doesn't matter. For me, at least, I can just trust the process and hope for the best. But yeah.